interact with this law to understand exactly what it means, its implication, and even how they can take advantage of it to be able to protect themselves as far as issues of data is concerned. So we thought it wise to have this discussion just to educate those who are participating in this webinar, but also to start having this conversation going out there to the people who it belongs to, that is the public. So we hope that by the end of this session, we shall have had an opportunity to understand more about the law, the Act, Data Protection Act, and also be at a position where we can be able to apply it in our respective businesses, respective individual levels, and wherever it is applicable, so that it can work for us, because the purpose of putting law in place is for it to protect us and also for us to be able to use it to achieve our respective endeavors in our lives. So we have a very strong panel of presenters who are going to speak to us. And then we are going to have a Q&A session where we are going to interact with the presentation that have been made. So looking at the program, how we are going to proceed is that we are going to listen to what are some of the key provisions of this Data Protection Act. And we have a lawyer amongst us, Ms. Catherine Kariuki. Catherine is a partner in charge of telecommunication, digital media, and technology at the OK Law. So basically, she has had an opportunity to interact with this law and be able to understand exactly what it means and how it can be applied in various situations. So Catherine is going to make a presentation just from that aspect. And then we are going to have what we call the practitioners, and that is Safaricom, who are our partners, to talk to us about the same law, but from the point of view of how it is affecting them as service providers, and what perhaps some of the measures they've been able to put in place to ensure that they're complying, but most importantly, to ensure that they're protecting the information they have in form of data. Because I want to believe that one of us here, in one way or the other, have a relation with Safaricom. I'm sure we all have a Safaricom line, maybe, and we want to be assured that the law is being applied to ensure that the data that Safaricom has on us is actually safe and is being put to good use. So we are going to have Ms. Fiona Makaka, Senior Manager, Customer Data Privacy at Safaricom, to speak to us. And they're going to share this presentation with her colleague, and that's Ms. Agnes Okello, who is also a Senior Manager in charge of Public Policy at Safaricom PLC. So the two are going to share that slot and share with us their perspective from Safaricom. And then we have also engaged the Office of the Data Protection Commissioner. As you know, this office was formed through the very act we're talking about today, and they have the responsibility to oversee its implementation and ensure that mechanisms are put in place that will enable us achieve the objectives of this legislation. So Rahab Juma, who is a legal officer at the Office of the Data Protection Commissioner, is going to speak to us from that angle and share with us their perspective as the people responsible for implementation of this act. So that's how we're going to run our program. Thereafter, we're going to have a plenary session where the participants will have an opportunity to comment, to ask questions, and also share their perspective, because all of us might have one or two information that others don't have. So you feel free to share your perspective when you get that chance. But if you have questions, we also encourage you to post them on the chat box because you might not be able to have an opportunity for all of us to ask questions. So we encourage as many of you as possible to post their questions on the chat box, and we'll be able to pick them from there and respond to them during the plenary session. So if you have one, just feel free to do that. And then when we get to the plenary, we'll ask that you raise your hand. I'm sure all of us by now know how to do that. And then I can be able to pick that from there and then give you a chance to be able to ask your question. And of course, if you get that chance, make it brief and to the point so that others can also ask their questions. So without taking much time, ladies and gentlemen, let me go to the main reason why we are here today and kick off with the presentation. So I'm going to invite Ms. Catherine Kariuki to take the stage. All presenters have up to 15 minutes to make their presentation. So if you can keep it within that 15 minutes, we'd appreciate so that we can manage our time very well. So Catherine, if you can hear me, I want to invite you to take the floor and make your presentation. And my colleagues from the other end, I think you can allow Patrick to share, Catherine to share her screen. I think I saw she was saying that she can't share her screen. So can I enable her to share her screen so that she can proceed with the presentation. So Catherine, please proceed.
Thank you very much, Henry, KARA and Safaricom for organizing this. And even as I wait for, yes, just give me a second so that I'm able to share my screen. I see now it's been enabled. Great.
Yes, we can see it.
Right? You can see?
Yes, yes, we can.
Great. As I said, thank you very much for the platform, for the forum. I have to say this is a good thing that KARA and Safaricom is doing towards awareness because, as you rightly said, it's still what we would consider, the Data Protection Act is still what we would consider a new law. And it's very important since it affects data subjects, the natural persons, the owners of this data, then it's important for them to be aware of what the Act provides and what the implications of the Act are. You've given me a very hard and tough task to be able to cover basically the foundations of the Act in 15 minutes. I'll do my best, but it means I'll probably end up leaving out a lot. So what I'll do is I'll be laying a foundation to what the other speakers will cover, Agnes, Fiona, and Rehab. Fun fact, we are all lawyers, but practicing in different aspects of, and in different industries in one way or the other. But so I'll lay a foundation of what Agnes, Fiona, and Rehab will cover in the presentation. And really what I'll do is I'll end up, I'll cover how we ended up with this act and where we came from as Kenya. And then I'll cover what we call the data subject rights, which basically what is the right that you enjoy as a data subject under this act. Then I'll also cover the principles to adhere to as if you're processing personal data in one way or the other, what is expected of you under the act. And then I'll cover what is called the lawful processing of data, or in other words, what is the justification that someone would be able to rely on when they're processing your personal data or personal information. So I'll use those terms interchangeably, personal information, personal data, but it's all the same thing. And then when I talk about a data subject, the Act only protects what we call natural persons. Because remember, you can hold data relating to a company, but what the Act protects is data relating to a personal, a natural person. So that said, I'll sift through. As I said, that is what I'll cover. And then let's look at the background of how did we end up with this Data Protection Act? It's a really, we came to the digital age, which I'm sure everybody is. We're operating in a digital age where we've even advanced so much. People are now even living in what we call smart houses or operating, smart this and smart that. So then because we live in a digital age, what jurisdictions or governments realized is it was impacting privacy in new ways that hadn't been thought of before. Privacy had previously been thought of in a very traditional way. And they realized that all these things that were emerging, that organizations and people were doing in terms of personal information, that they could put one data set with another data set together and make conclusions about you as a person, for instance, credit scoring, the different things today, by someone having certain information about me, they can even conclude issues regarding my conscience, my reliability as a person, and things like that. So government realized, oh, there was this new aspect that was affecting privacy. There was also the commercialization of data, and they were looking at it and saying, how can we give power back to the data subject so that we balance it, so that as much as your data is being used, let us give you back the power so that now you're aware of when your data is being used. You can even control how your data is being used. And this is the age of data mining also. I hope it's a familiar term. And so that what we've seen is that data, well, before this data would be collected and would sit somewhere. In this day and age, all kind of things are being done in the background with the data that's collected. And as I said, things are being done where the government have looked at it and said, no, let's give power back to the data subject. There's also the aspect of artificial intelligence, which if certain information is fed into a system, it's able to apply certain levels using algorithms and other things. It's able to apply certain levels of intelligence and come up with certain conclusions, which wasn't being done before. And what the law is saying is, like, for instance, should some systems determine my reliability as a person, my honesty as a person, and then that's why the law came to regulate all this. So then what the Data Protection Act has done, or what the privacy laws have done, is shifted the dynamic, so that now the data subject, given back the power to the data subject. And the conclusion of the privacy laws is that individuals should be able to choose what space within their personal domain can be accessed by others. Literally, you should be able to control the scope of what they do with your data and why they're collecting their data. So it's more of like awareness. So it doesn't restrict that personal data cannot be processed, but it says we're giving you, the data subject, the power back so that they are aware and they give their consent, or at least they know to what extent their data is processed. So then the background, we came from the Constitution. So we've had Article 31 has always guaranteed the right of privacy. But what the Data Protection Act did, and it came from the process of the bill and made its way to the act, is now it tried to expound this right of privacy, so that it provides specifics, or it enumerates this right that is guaranteed to you as a person in the Constitution. This Data Protection Act expounds it and now provides specifics, like issues of consent and things. And this, it really expounds it, yeah? So then the impact of this act, what it ends up doing is that it shapes the way organizations and governments, I would say businesses and governments, how they approach privacy, so that it's harmonized. So that when someone tells you, I am Data Protection Act compliance, they're all reading from the same script. So actually it was to harmonize that, because one version of that we respect privacy will not be the same version for another organization when they say we respect privacy. So then it realized the need to harmonize this privacy so that they all read from the same script. It was also easy for data subjects to be able to know what to expect. For instance, today, if I ask you, or at the end of this session, if I ask you, what rights do a data subject enjoy? Does a data subject enjoy under the Data Protection Act? You'll be able to tell me, because it is there. It is enshrined in the law. So then that was one of the things that it sought out to achieve. Notably, and this is to mention, there over time, even before the Data Protection Act, there were other laws that carried aspects of privacy, but within the different sectors that we have in the industry. So for instance, for the longest time, the Banking Act has always had very strict privacy and data protection laws as far as customer data is concerned. Then there's the Kenya Information and Communications Act, and other acts have also. But what it did, you see, if you're regulated in that space, that's when you would have to adhere to those privacy laws. But now what the Data Protection Act has come is it covers everybody. As long as you're a resident of Kenya, you're protected under the data, your personal information is protected under the Data Protection Act. So then we're going to look at two concepts. One is data protection, the other one is privacy. And we're going to look at them because throughout the act places all these obligations on people or your rights, they're in relation to either data protection or privacy. So when it comes to data protection, it really, data protection looks at literally that it's self-explanatory. It looks at how one who holds or who processes personal information, what are the safeguards that they put in place, whether technical or organizational, to make sure that that data that they process is protected. Because remember, we live in an era where data breaches are concerned, in the era of cybersecurity, and most cybersecurity experts always tell us that when it comes to a data breach, it's not a matter of if, it's a matter of when. So then why it covers this broadly is, it says if we put in place measures that you have to put in place to safeguard a data subject's information, it is important, and in a way we've also protected the data subject. So then the Act goes on and on and on about the technical and organizational safeguards that have to be put there, but the rationale is really that, to protect the data. And also we live in an age where in case of a data breach, I'm sure we've heard of situations where a data breach has led to, say, identity theft, because people were able to access credit details and other details of data subjects. There's also the issue of fraud. So usually that's why the Act covers a lot of that. Then when it comes to the privacy aspect, it's because of the constitution aspect. Remember, I said the Constitution guarantees your right to privacy, your personal affairs. So it tries to now bring in the balance of between when you voluntarily give your data away versus when you choose. It gives you choice and awareness. So then, as I said, the purpose of the Act, which I've covered before, is that governments and businesses are expected to adhere to provisions of the Act in order to guarantee integrity of data. Okay, so now let's look at another aspect of what is personal information and other categories. So the Act gives two categories, right? There's what we call the sensitive data and the general data. And the only reason why it separates these two is because there's a higher threshold of data protection and privacy requirements when it comes to sensitive data. So sensitive data is what is listed there. And when you look at it, you're able to conclude why it's sensitive data. So as you can see, health data, ethnicity data, all this is data which would be regarded as sensitive. And so you'll find that people who process or hold personal information that is of this nature are held to a higher threshold. So like insurance companies, hospitals, they're held to a higher threshold as compared to other organizations. So then there's also, under the Act, there's also the threshold that's provided for mandatory registration. What the regulations provide is that some people must register with the Office of the Data Protection Commissioner, and it provides a certain threshold, or what we call the low-hanging fruits, the people who operate in industries. When you read, you can easily be able to conclude that these are people who operate in industries that are either personal information heavy or sensitive data heavy. Yeah. So the first threshold, they say, is annual turnover of 5 million. But then it goes ahead, even if your annual turnover is, say, below 5 million, there are still some specific sectors which would bring you under the ambit of the Act. And what the Act does, it tells them, you register with us. And then when you register with us, there's some things that you have to provide. And then there's also continuous compliance that will be monitored. And maybe Rehab, when Rehab covers this bit, she'll be able to cover it a bit more extensively, but that's the threshold. So all these industries, if you operate in these industries, you're expected to be compliant, and they're quite a number. So then another aspect that we'll cover is data subject rights, right? Remember, I said one of the aims of this Act was to give power back to the data subject, yeah? So that, and it does this by giving the data subject some rights. So it gives you some rights that as a data subject that you enjoy under the Act. And this is right to be informed. Right to be informed just means that if someone is collecting your data, you need to know that they are processing your data and how they're processing it. Information, right of access. Right of access means that a data subject should be able to access information that someone has about them, or the controller or a processor, what information they have about them. You should be able to access this. And it's provided for, like in that case, 7 days. If you request within 7 days, you should be able to get back the information that someone holds about you, all the information. And this includes all the information, right? Because remember, it's very possible that today you collected my name, next month you collect my mom's, I don't know, ID, the other month you collect this. So I should be able, if I come to you and I ask what information do you have about me, you should have it in a form where you would be able to tell me exactly what information you have about me, including all those back-end things that you do and process my information. I should be able to access that. Then there's a right of rectification. And this one really gives people the power back, where I know that the data that you have about me is erroneous. And I know that maybe if you're applying AI or other algorithms, the result is actually affecting me negative. So I should be able to ask you to rectify that data, erroneous data that you have about me. There's a right to erasure, which basically just, it's also called the right to be forgotten, where I can tell you, organization X, you had this data about me. I'm no longer your customer. I would like you to forget me. Erase all the data that you have about me. You cannot continue holding this data about me. There's also the right to restrict processing, where, despite the fact that you have my data A, B, C, D, I can tell you, because maybe A, B is erroneous, I'd like you to restrict processing regarding A, B, and you can process C, D. You enjoy that, right? There's also the right to data portability, which just means that you should be able to access, after accessing this information, you should be able to request for organization A to maybe transfer this data to organization B in a certain form or in a certain medium. It provides you of this right as long as you've requested for the same. There's also the right to object, and it's tied together, like you can object to processing if you feel that they're processing certain information, your personal information, in a way that's negative or in a way that doesn't meet the objective for which they collected it for. You have the right to object this processing. Now, having looked at data subject rights, we're going to look at the principles of personal data. So in the first instance, the Act gives a gift to these data subjects and says, you have these rights, which anyone who is processing your data can, you can enact these rights against them. Then it jumps on this other end and says, you as someone who's processing data, whether you're the organization, whether you're government, there are these principles that you have to adhere to if you're processing any personal information. And as an organization, so it usually comes down to your policies, organizational policies that you'll have, the organization measures that you put in place, or the technical safeguards that you put in place. There's lawful, fair, and transparent. And this is a very important one to note, because later on we'll look at what it means to process information lawfully, because this creates the justification for most organizations that go ahead and process your personal information. There's also storage limitation. Gone are the days when people would collect information and keep it, personal information, and keep it in infinity. Now there's a limitation, and you need to tell someone for how long you'll keep in this information. There's also purpose limitation. Gone are the days when you would show up at the security gate of an institution and they ask you for your ID, your mother's ID, your dad's ID, your fingerprints and everything. It has to be relevant, yeah? And also if you collect it for one thing, and you'll see it ties down to minimization. Also, if you collect data for one thing, you cannot use it for something else. That's the purpose. If you collected it for a certain purpose, then you cannot go ahead and use it for something else. There's the principle of accuracy. Remember, I just talked about how the data subject enjoys a right to rectification. So you're expected to keep the integrity of data and to keep data accurate at all times. So upholding the right of privacy goes back to the Constitution, Article 31 that we talked about. There's transparency and accountability, which just means I need to know what you people are doing in my personal data. And most people adhere this through a privacy policy, where you'll see a privacy policy telling you, generally, this is how we handle personal information in this organization. Then there's explicit, specific, and legitimate purpose, which we touched on earlier, and the principle of minimization, which I also touched on when I was talking about purpose limitation. When it comes to justifications, remember I said that you need to note when you talked about lawful processing. So lawful processing is when most people collect your personal information or process your personal information, they will usually rely on one ground or the other. The most common ground that people talk about is consent. But interestingly, consent is not the only ground that one can rely on. Find it's the most commonly used and most widely used, but consent is not the only ground. There are other grounds that people rely on, yeah? So there's consent, and consent, the regulations go deep about also what is valid consent, what is not valid consent. We won't cover it today, maybe we'll cover it in the next session that KARA and Safaricom will organize. But then the second ground is legal obligation. Legal obligation just means there's a basis in law. So like policemen, when the policemen process your personal information, they have a basis in law. When KRA processes my personal information, they have a basis in law. When my finance department processes my personal information, say to file their tax returns or to file my PAYE with KRA, they have a basis in law and they don't necessarily need to get my consent. Yeah. So these are the grounds I usually relied on mostly where consent is not easily available, say, or can't, it would be a nuisance to say that we can only rely on consent. There's also performance of a contract with the individual. This is very common in commercial relationships. Most people will rely on performance of a contract with the individual. So like when, says like Safaricom onboards you, and you sign the terms and conditions for a certain product, that's a contract. And on that basis, they will have a justification that we are processing this information in the process of performing a contract with them. There's also legitimate interest, and this one usually arises in a relationship context where it's obvious, it's common sense that personal information will be processed in that context. So like in an employer-employee relationship where a client, like you walk into my law firm and I will need to process some form of personal information when I'm acting for you as a client. And then there is to prevent fraud, the direct marketing where you're already a client. Say like you go to Optica and you buy glasses, and then they send you a message telling you, we also have this kind of glasses. Or a developer, you bought in phase one, you bought some units in phase one, and maybe they have another development project and they tell you, hey, by the way, we are contacting you. We also have this in phase two. Would you be interested? Yeah. So they would rely on legitimate interest. And there are also other grounds that are put there. There's protection of a vital interest of a natural person. This one is usually in the context of to protect life or in life-threatening situations. So for instance, let's say if someone gets an accident on Agwins Kothek and is rushed to Nairobi Hospital, in that case, you don't have the chance to start, Nairobi Hospital has no chance to start asking the person, we need to process your personal information. Can we get context? Can we get consent? So in that context, what they'll do is they'll draw blood, do lab tests, be able to determine this person's blood group, medical status, and all those things. So they can rely on that, protection of vital interest of a natural person. There's also public interest, which most public institutions would rely on. And in this one, it usually occurs in the context of official functions with a clear basis in law. And most public institutions will end up relying on this to process your personal information. So as I had mentioned earlier, the common documentation in this context, you will come across a privacy policy and terms and conditions, which I've touched on. So when it comes to compliance and enforcement, which I expect that Rehab will probably expound on a bit later, but when it comes to compliance and enforcement, we have the Office of the Data Protection Commissioner. I didn't want to assume that everybody here is familiar with that, but there is the Office of the Data Protection Commissioner, which basically is the regulator when it comes to matters of privacy and data protection in Kenya. So it usually deals with where data subject can initiate their complaints, and then investigations are done in this context. And the specific regulations that they use to govern this is the data protection compliance and enforcement regulations. So I know that they're currently in the process of setting up the infrastructure to receive at least the mandatory registration, and I look forward to hearing what Rehab can update us on this. But that's on enforcement. And so that's a broad overview. Henry, I hope I've stayed within the 15 minutes that you allocated me. And that forms a foundation, basically, of what Agnes and Fiona and Rehab will cover. So I look forward to hearing what they have for us. And maybe what we'll do is at the end of the session or in the Q&A section, we can continue engaging and see how it goes. So thank you very much.
Thank you very much, Catherine, for that very incisive presentation. You certainly have laid the proper foundation for the next presenters to be able to carry on from there. And you've touched on a number of areas which I don't want to repeat, but I'm sure so far a lot of learning is going on. Personally, I've learned a number of things from your presentation. But because we are also chasing time, I don't want to go through what you've said. What you can do, participant, is that if there is a question or there's something you need to clarify or ask later with Catherine, please note it down. And when you get the chance, you'll ask. Or as we said, post it on the chat box. And I want to encourage the panelists that if you see a question directed to you on the chat box, you can just respond through the same mode. You can just give a response on the chat box so that we also don't take much time during plenary. So having said that, ladies and gentlemen, like I said, now we have Safaricom, who are the operators, and basically people are supposed to be applying this law in the course of their service provision. And we have two presenters, I mentioned that earlier. So we have Fiona Makaka, who is Senior Manager, Customer Data Privacy. And I want to believe she's the right person to answer the many questions people have been asking out there. How safe is our information in Safaricom? I remember a few months ago, there was a bit of hue and cry when we were being told to go and register fresh, and people asking so many questions, and the issue of data privacy came in. So Fiona, I believe that you've encountered many questions even before today about data privacy. And we want to hear from you on what exactly is happening at Safaricom in this regard, and what mechanisms are you putting in place to ensure that we are safe as far as our data is concerned and we are compliant to the law. So please take the floor and speak to us, Fiona.
Thank you so much. And thank you to KARA and to ODPC. I am just trying to share my screen. Please confirm if you can see my screen.
Yes, we can see it.
Are you okay? You're able to see. So I just wanted to start by saying thank you. This is a great step towards collaboration. It's good to see platforms where the ODPC, Safaricom, and organizations like KARA coming together to just kind of handle and talk about what data protection means and what we can do to protect the consumers. It's very important for us to understand that data protection, it's not something for Safaricom, it's not something for telcos or banks only. It's something that even KARA has an obligation towards complying with. So even you as KARA, what are the steps you've taken to comply with? So the scope is quite wide in terms of who is responsible for protecting. It's not only protection of customer data, you have employees, you have suppliers, you have maybe shareholders. All these people have to be protected as long as it's an individual. I'm quite excited to be here today, and I'm just laughing because today morning we were actually together with Rahab ODPC trying to figure out how to register as controller processor, and I guess she's going to talk more about that. So Catherine has actually covered a lot of the basics, lawful processing. What are your rights as a data subject? If they don't collect consent, can they still use my data? And we're going to not focus on that so much, but we're going to, first of all, let's just look at the current trends, what we have been seeing across the globe, not only here, but when you talk about some places like Amazon, which we thought, Amazon has the best privacy controls. When you talk about some areas like Facebook, WhatsApp, everywhere we are seeing trends where privacy is increasingly becoming a concern for the consumer, and we do need to give assurance and protect their data. Closer home, Safaricom, we've seen a bit of questions about M-Pesa. We've seen a bit of concern about spamming, and we're going to address this and together with Agnes Okello, we are going to just address some of these things and just give assurance to all of you. So there's the Data Protection Act. This is the snapshot of the Data Protection Act, because Kate has already gone through this, and because we don't have much time, I'm just going to skip through that. She's also managed to go through, what the principles are, and what do they mean for a telco. This is one of the questions that had been posed to us. So, the principle of transparency, this is really, we are being told we need to be transparent when we collect data, when we share data, when we do anything, you have to be transparent. And I know a lot of you have seen right now, when you download anything, maybe it's Google Maps, maybe it's even WhatsApp, they actually ask you, are you okay with the app having access to maybe media or to anything else, and then purpose limitation. This Kate has also gone through, so I won't dwell on it. A lot of us, have had stories of maybe there's a certain lending company, a digital lending company that you have actually said it's okay, you can have access to my data. And without telling you, they go ahead and actually call your whole contact list. So that is what the Data Protection Act has come to say. You can't actually do that. And minimization, do not collect too much data. And we're going to just unpack this, and just see what it actually means. We have a duty also to ensure that we have accurate data. So anytime we pick data from you, a lot of you have seen that we ask for an ID. So you can't just tell Safaricom that your ID number is 12345, and we just we say, okay, that's fine. We actually have to see the ID, and a lot of times we do a check called an IPRS check to figure out if this is actually, you're actually the person you say you are. And also the last two principles are retain what is relevant. In terms of storage limitations, store for only a certain amount of time. And lastly, you need to put controls, technical controls, to ensure that only the person who has a need to know or who has a need to have visibility over the data has that visibility. Now, Kate has also gone through this. I don't need to go through it. And, in answering some of the questions that came up, maybe Agnes is going to touch on some of the lawful basis. So as a telco, these are the things you need to think about. When you're collecting data, when you're processing for one reason or the other, does it fit under any of these? As Kate had mentioned, you do not, it's not always that we are relying on consent. You can rely on any of these other ones, including vital interest, but it does have to fit within this. Otherwise, you are processing data in violation of the Act. Now, coming into what are the controls that we've put in place, and what are the controls you can implement if you're a telco or even a controller or anything. So in Safaricom, we have the organizational controls and also the technical controls. So when it comes to data protection, it's not just that you do a policy or something and then you leave it at that. You also need to technically make sure that that data is protected. And we're going to just go through that in a minute. So the first thing you want to think about is, the strategy and governance of it all. Who is responsible for that? So if it's KARA, who in KARA is responsible for data protection? So do you have a dedicated team? So like in Safaricom, we actually have a dedicated team that is purely deals with protection of your data and your privacy. And we also have a committee, just to make sure that everything is in check. So it is very important for any organization that's dealing with data to have roles and responsibilities. Sorry, I can see my internet is unstable. Can you hear me? Please confirm. Are you able to hear me? Any of the panelists can confirm.
Yes.
It was breaking a bit.
Yes, we can, Fiona.
Okay, thank you. Thank you, guys. Please let me know if you can't hear me. Any of the panelists can just speak so that I do the needful. So that's the first thing, strategy and governance. Who is responsible? And then you have the, when you go to technical controls, you have the access control and login. Not everyone should be able to have access to a customer or even employee, as long as it's personal data. You need to have some access control, and it needs also to be monitored. So, for example, maybe there's Raymond who has access and is actually has clearance to have access. You still need to monitor so that if he has accessed and then there's a leak, we have some sort of an audit log to show that it's actually Raymond who accessed it. So this is some of the technical controls that you can put in place. We also have something called incident response. You have to have an incident response mechanism, because from time to time, like let's say when a suspected incident happens, it might not actually be an incident, it might just be something that ends up not being an incident. But when it happens, you need to be, it's not the time to start looking and figuring out who should you tell, who should you. So you need to have a response in time. Remember, and Rahab is going to confirm this, you have 72 hours to tell the commissioner that you have a breach. So you don't have time to wait for the next day and then try to figure out. So you have to have something in place already there that can actually, once there's a suspicion that there's a breach, immediately, you do triage, you do investigation, and then you start monitoring and just trying to figure out in terms of time, are we within time? Because you have 72 hours to report it. And even the report requires to have a bit of information. So you just can't go and say, I suspect, but I'm not sure. You need to have done some investigation. So the other thing that it's important to think about is risk management. And this is done through, we do internal audits and external audits. I know I've seen a few of our internal auditors who help us and keep us in check are actually here. They make sure that, we have actually protected the data. And that's just one line. Apart from that, there's also external auditors. So we have, the major auditors or consultants. So people like Akina Catherine, people like Akina Deloitte, they actually come in and just look at it and tell us if really what we have done is in line with law, or there are some things that we actually need to change. The other thing that we do is, you just monitor 24/7 monitoring. You also make sure anytime you're bringing in a supplier, and a supplier does not need to be a technical supplier. It could be someone that you're not thinking about, because even a security company is a supplier. And actually, for most of us, security companies are the ones placed at the gate and they take the data. So even them, they need to comply with some minimum requirements. So make sure you have the minimum requirements, and data protection is part of it. So then remember, Kate had talked about data subject rights. So when it comes to data subject rights, make sure you have something in place to ensure that when someone wants to exercise any of the rights that Kate talked about, whether it's portability or right to be forgotten, there is a dedicated channel. So in Safaricom, we actually have a channel. It's an email address, dpo@safaricom.co.ke. So this is a dedicated email address that purely deals with data protection requests, where you can actually come and say you want something, and then we are able to respond. We are able to figure out how we can assist and give you assurance. And then remember, I talked about technical and organizational measures. So when it comes to organizational measures, we are talking about, it's very document heavy. So document heavy means, it might not look like a big deal, but it's actually a big deal to have policies in place. An internal policy that tells the employees that when you're handling identifiable information of a customer or of any, it could be a shareholder, it could be a supplier, then you need to handle it like this. If, for example, do not save it on the desktop, those kind of things that they know it. Then you also have to have a privacy statement. We have a privacy statement on our website where people know their rights, people know who to contact, people know they have a right to actually even contact the commissioner. So just be open, be transparent, And then also awareness is important, not only awareness for internal facing teams, but also awareness of people around you. Who are the stakeholders and who are the stakeholders in the ecosystem, yeah? So you have not only your suppliers, maybe you have partners. You know, like Kara, you can say actually maybe you deal with Safaricom a lot. So we are your stakeholders. So, you know, when you're looking at it from that angle, you realize that you actually need to also do awareness for everyone, so that it's not a situation where Kara, you know your obligations, but no one else around you knows your obligations. So for us, we do awareness even for our M-Pesa agents and try to make sure they understand the gravity of it and the need to do. We also partner and collaborate with the data commissioner, so that if there's any campaign they are having, we are able to just push it along and push it on our channels. So this is just the organizational measures, but the organizational measures have to be complemented with the technical measures. So you can't just put policies in place and do awareness and leave it like that. You also have to do this access control, cybersecurity monitoring, login monitoring. These are very important. And that's it from me. I hope I've not taken too much time. So maybe I'll just invite Agnes. Maybe Agnes, you can just touch on some of the few things that you know, the customers are actually concerned about, some of the things we were asked to cover. Thank you.
So thank you very much, Fiona and Catherine, for setting the context. I think it's becoming clearer now to our audience that really this data protection legislation is not just a good piece of legislation written on a paper, but is something that is actually implemented by real businesses. Thank you very much, Catherine, for outlining the salient features of the Act and the regulations that are coming into play. And Fiona, for demonstrating to our audience what Safaricom has put in place to ensure that we comply with the Data Protection Act. So I will not go much into the details that have already been shared with you all before, but pardon me, good afternoon to you all. Pardon my manners, I had forgotten my salutations, but mine is to paint a picture for you, or rather bring the picture that has already been painted for you to appreciate that this is real and it applies to each and every one of us. Most recently, we've actually had a run at this Data Protection Act, both the audience as our customers and we, the business representatives who were charged with implementing it. So you do remember from last year, September or thereabouts, your respective mobile network operators requested each and every one of you to visit their shops or visit their agency shops so that you can provide your registration details. And we specifically asked for you to provide your identity cards, be they your national identity cards, be they your passports that you use to register if you're a foreigner, be they alien cards that are issued to foreigners who've been naturalized into Kenya in one way or another. So, of course, that elicited a lot of buzz in the market of, you know, Safaricom is collecting all this data. Why is Airtel asking me to visit their shop to provide my ID? Why am I being required to pose and take a photo? What is it going to be used for? And, you know, all that. So this is something that is very much with us even now because the exercise is going on. And so for me, I wanted to relate that exercise to the Data Protection Act and to the systems that Fiona has shared with you, or the policies that have been shared with you as being implemented by Safaricom. So the lawful basis for that particular exercise is drawn from a regulator's directive. And by this regulator, I'll refer to them as the CA, the Communications Authority of Kenya. So the CA did write to all the mobile network operators and say, in order for you to comply with the conditions outlined in a different set of law, not even the data protection law, but the Kenya Information and Communications Act, you need to collect registration details of your customers. And what happened is that in the past, we had collected registration details, but we did not have documentary proof of the registration details. And that bit of the law is very much there, and we were required to do it, so, or to implement it. So for us to be 100% compliant with the Kenya Information and Communications Act, we were required to come back into the market and ask you, our customers, to come and provide us your copies of your identity documents. Of course, that is looked at in light of the Data Protection Act also. So we went back to the Data Protection Act to look at, does that suffice as legal basis? Yes, it does. Legal basis could be from a contract that you have with us. It could be from an operation of law, where a certain law requires that we collect that data from you, or it could be an order of court. All those form legal basis for one to collect data from a data subject. And so, having satisfied ourselves that we have a good legal basis, we move on to the next point, which is what is the data that is required and what is it required for. So again, the principles of data minimization come into play, and relevance of the data that is being collected to the purpose. So purpose limitation also comes into play. And the Kenya Information and Communications Act is very clear on what is to be collected from a subscriber. So we did require, or we do require, that our customers provide their names, their identity card numbers, copies of those identity cards that they're using to register, details of their addresses, and the numbers that are being registered against those IDs. So having satisfied all those, then our agents in our various shops or our distribution channels then would request you to provide the ID, and they have to see and ascertain that the data that you're providing is accurate. So they have to see that ID and collect a copy of it. Having walked this journey hand in hand with the ODPC, the Data Commissioner, as well as the Communications Authority, we assure that we do have a strong legal basis for us to request for registration details from our customers. And we, as you have seen, as demonstrated by Fiona, we also have very robust systems, and we put in place policies and measures to ensure that your data is secure with Safaricom, as well as the other operators, because it is required in law that before you ask that a data subject gives you that data, you have satisfied the security requirements for you to collect, store that data, and maintain its integrity for its lifetime with you. So without further ado, there were a few questions that had been shared with us beforehand, and which speak into the practice of implementing the Data Protection Act. And I just wanted to respond to a few of them, even before we get to the Q&A section. And the first question had been asked by Sharon Buluma. She asked what measures we had put in place for us to deal with data breaches in relation to advertising. So the kind of advertising that we understand Sharon is speaking to here is the advertising that comes to your phone via messaging, and we call that promotional messaging, where you'll be informed that there is this offer that is running. Would you like to subscribe? For you to subscribe, please do this and that, and you'll be able to enjoy the benefits of that promotion or that service. And for that, I would like to draw the attention of our audience that over and above the Data Protection Act and the Kenya Information and Communications Act that speak to data privacy around the telecoms business, we are also licensed, and in our licenses, we do have license conditions that speak to data privacy. So you can see that we are operating in a very tight space where we cannot afford, even if we were able to wiggle or find gray spaces in the Data Protection Act, then we'll be caught on the other side by the Kenya Information and Communications Act. If we escape that, then we are caught by our license conditions, for which if we do not observe, then we would not have a license to operate. And one such condition is that we do not spam or we do not send unsolicited messaging to our customers. Now, Catherine earlier alluded to terms and conditions that you do consent to, which form a contract between you and your service provider. And in this instance, Safaricom does provide you an option to agree to the terms and conditions when you subscribe to our services. If you do take your time, and I know a lot of us don't read terms and conditions, but somewhere in there, and I assure you we have not put it in fine print, that we have outlined it to you that we will be collecting your data and what we will be doing with your data. And some of the things that we can do with your data is to market to you services that are relevant to your use. And so at Safaricom, we very strictly observe that, where we ensure that before we send out promotional or marketing messages to you, we ensure that you did consent to being targeted for that kind of marketing. Further, we provide you an option to opt out of the promotional messages that you do not want to receive. So you have seen some that the messages come with an option to block or to opt out, *456#, and that remains live. The downside to it is that you will lose out on the communications that we send out on the exciting offers that we put out for customers. Nonetheless, we do understand that some customers know exactly what they want, and they want their peace and quiet. So we do avail the option of you subscribing or choosing the silence by dialing that code, the *456#. Additionally, over and above our services, we have partners who market through us. And depending on the kinds of services that you go out there and you procure, and I'm sure a lot of you have received, messages, say, from Java, from LC Waikiki, and all those other places where you shop from. They too are required to obtain your consent before they market or they send you promotional messaging. And what we have done on our part at Safaricom, because they use our platform, is we have incorporated in our contracts with them requirements that they obtain consent, that they will not send messaging to customers who do not wish to receive them. And with every message that they send to you, they will give you the option of unsubscribing from receiving promotional messages. You've also seen this from banks. When you're signing up for mobile banking, there's somewhere in that form that they give you to fill in to sign up for mobile banking that says, do you wish to receive promotional messages? And a lot of times we just tick the box without thinking much about it. But then all is not lost even if you did consent or agree to it. The only unfortunate thing, like I pointed out early, is you may end up losing out on very attractive offers that are given by your service providers when you choose not to receive the promotional messages. So what happens in the event that they breach? Because on our part, we do ensure that we hold our end of the bargain in our direct relationship to you. But when our partners breach that, we have our contracts provide certain measures that we can take action against them to ensure that they do not bother you. Nonetheless, we also avail you the option of opting out, and where you require assistance, our customer operations teams are always very eager and willing to support our customers with any challenge that they are having. The second question that was raised is on the limitation of mobile phone numbers. And well, there is the perception that we do limit the number of mobile phones, but I would just like to put that in context. It's that we do not necessarily limit the mobile numbers or the mobile phone numbers that one can have. But once a customer has hit a certain threshold, then we subject them to a higher level of know your customer requirements, or KYC. Because we do study customer behavior, and we do understand that a normal customer would definitely require, like, say, this number of lines for them to have effective communications. But then if they do require more, because we are aware that we are no longer just a telecommunications company, rather we are a technology company, and your SIM card or your line is not simply for making phone calls and sending SMSs as it were a decade ago. Now you can do much more. And the fact that you can do much more with it means fraudsters can also do much more when they are able to steal your identity and access your line. And so that is why we have put in a measure to protect our customers and say, if you do require more lines than is assumed normal and necessary, then you'll be subjected to a higher KYC. Nonetheless, you're not limited. If you have good justification, then certainly you can have additional numbers. And then Pauline Kamunya, you did ask what kind of data that Safaricom shares and with whom we share. So Fiona had shared that we work with a number of suppliers and partners. And for that reason, depending on the kind of service that you procure from them or we provide them, then we may need to share your data with them. However, this is done in the strict confines of the law to ensure that they too have the legal basis to require your data, and that they have the security requirements to collect that data and store it. As we are progressing in this data privacy journey, that they are duly registered. So they're also subject to oversight by the ODPC, and I'm sure Rehab will shed more light on that. And then there was a question by Benjamin Bella on how one can incorporate data protection in their businesses. And I think for this, let me not speak for the regulator. I will let Rehab guide on that, because then I would, she would require to understand what kind of business are you and what would be applicable and what would not. And then finally, in this session, the question that came is, does the Act complement the Computer Misuse and Cybercrimes Act? Yes, it does, because when your data is secured, then you're able to identify, or we are able to identify and very easily tell who is using data, who is misusing them. The Data Protection Act allows us to process your data in certain ways. And so it complements very much the Computer Misuse and Cybercrimes Act, sections of it that are not subject to judicial proceedings, as it were. So I will leave it at that, and hopefully if there are more questions, then we can tackle them in the Q&A. But thank you very much, and I think I hand it back over to Henry.
Thank you very much, Agnes, for the presentation and even for responding to some of the questions that were sent in advance, which of course we had more that we'll share with the other panelists. So we are progressing very well, and like I said, we're almost getting to the Q&A session, which will give you a chance to also respond. So I'm going to encourage the panelists once again to try and respond to questions on the chat box, so that maybe when you get to plenary, we'll only take questions that are being asked directly by those who shall have raised their hands. So without taking much time, let's now invite Rahab Juma. As you heard, Rahab is from the Office of the Data Protection Commissioner, and they are essentially the regulators in this regard. So Rahab is going to speak to us what the regulators are doing or have done to ensure that we are on the right course as far as implementation of the law is concerned, but also just to ensure that us as people who are stakeholders, so to speak, are getting this information and we are playing our bit, because to every law, there's a responsibility of citizens. So we need to understand how we can play our role and support the process of making the act to achieve its objective. So Rahab Juma, please, if you can hear me, take the floor and make a presentation.
Thank you, Henry, and good afternoon, everybody. I hope you can hear me.
Yes, you can.
So I'll go through the presentation and some of the questions that were sent to me earlier on, and then I'll take a few questions from the attendees and from the chat section. So let me just share my screen. So I hope you can all see my screen. So I'll take you through briefly what we do as an office and what is our role as a regulator established under the Data Protection Act. So as Catherine had mentioned earlier on, there were many motivating factors to have a data protection framework in place. And from the policy perspective, we have the Vision 2030, which recognizes ICT as a critical driver and enabler of the Kenyan social economic development. And ICT is pegged on the exchange of information or data for us to be able to enjoy services over the internet. So that was one of the motivations. We also have the 5-year medium-term plans that was developed with the government coming into place as well, that acted as a motivator. And then also in terms of the policy framework, we have the National ICT Policy. We have the Kenya Digital Economic Blueprint for Africa. And also we have the draft digital economic strategy for Kenya, which is a 5-year implementation roadmap that operationalizes the digital economic blueprint for Kenya. And also lastly, we have the data protection and privacy policy of 2019 that was actually assented to by the executive prior to the enactment of the Data Protection Act. So in terms of the legal framework, I think this was touched on. So we have Article 31 of the Constitution, which speaks to the right to privacy of an individual. So privacy from the aspect of the information relating to you as an individual and also as a family, and information relating to your private affairs not being unnecessarily required, and also the privacy of your communications. And then we also have Article 35 sub Article 2 of the Constitution, which recognizes the rights that every individual has to the correction of false or misleading data about them. So we are established as an office and as a regulator, we are established under the Data Protection Act of 2019, which came into law in November 2019. And then subsequently, we had the Data Commissioner being appointed into office a year later in November of 2020. And then subsequently following that, we had earlier on this year, we had the gazettement of 3 sets of regulations that actually come into place to operationalize the Data Protection Act. The regulations are the Data Protection General Regulations of 2021, the Data Protection Complaints Handling and Enforcement Procedure Regulations of 2021, and lastly, we have the Data Protection Registration of Data Controllers and Data Processors Regulations 2021. So in terms of our mandate as an office, what do we do? Our key mandate is to regulate the processing of personal information. Secondly, we ensure that the processing of personal data of a data subject is in accordance with the principles that have been touched on. We also ensure that we protect the right to privacy of individuals. And we are here also to establish a legal and institutional mechanism to ensure that personal data is protected and processed in accordance with the principles, and also to provide data subjects with rights and remedies to protect their personal data, and to ensure that the processing is in compliance with what the law requires. The functions, our functions as an office range from enforcement and implementation. I know enforcement and compliance has been talked about. We have a responsibility to ensure that we enforce what the law provides and also oversee implementation of the act, not only by data controllers and data processors, but also on our end. Another responsibility that we have is to register data controllers and data processors who are operating within our ecosystem. And it's prudent for us to note that the scope of the Data Protection Act is extensive in that we not only do we regulate people who process personal data in Kenya, but anybody who's dealing with personal data of a Kenyan resident is also required to comply. So assuming there's an entity in South Africa that is processing your data as a Kenyan citizen or as a Kenyan resident, the expectation is that they will comply with the legal framework that we have in place. We also have sessions where we also have the responsibility of creating awareness, such as attending such stakeholder sessions whereby we raise awareness on what we do as an office. We also have the responsibility to carry out investigation, conduct assessments, research, inspections, as well as international cooperation. And what this entails is us cooperating with other data protection authorities all over the world to ensure compliance with the data protection principles. So I think the scope of personal data was touched on by Catherine. Personal data, the definition we have under the Act of Personal Data is any data that, number one, can identify you as an individual, or number two, has the potential of identifying you as an individual. So anything and everything under the sun is capable of being personal data. If it identifies you, and secondly, if it has the potential of identifying you. A good example would be your IP address. It might be just numbers on your screen or a number on your URL. But at the end of the day, if I'm able to get your IP address and combine it with various data sets, let's say if I combine it with a data set from your internet service provider, I'd be easily knocking on your door any day, anytime. So that's why we need a framework in place that will make sure that personal data is protected. I'll skip through the slides that have already been touched on, and because I know we are a bit tight on time, and focus on the things, focus on the compliance aspect and our role as a regulator. So we have, in the realm of data protection, we have two parties. We have who we call the data controller, and also the entity referred to as a data processor. The distinction between these two entities is that the data controller is the one who has the decision-making power at the end of the day. They're the one who, they're the entity that decides what will be done on this data that has been collected, and what means of processing, what means this data is going to be processed. The data processor, he just does, or he acts under the instructions of the data controller. So that's the distinction. So if you want to know where you'd fall, you'd look at whether you have the capacity to actually decide on the data that is being collected, how the data is going to be processed. And if not, if you work under the instructions of someone else, then automatically you become a data processor. The principles have been touched on, so I'll skip to the next slide and focus on the rights of the data subjects. We have the first two rights of a data subject, which is the right to be informed and the right to access personal data. The uniqueness of these two rights is that they are unlimitable rights in that they cannot be denied. So in any instance where someone is collecting your personal data, they have a right to inform you, number one, why they require your personal data, number two, to what purpose will that data be used for, number three, how long that data is going to be kept, and number four, whether that data is going to be shared with any other person. And then when it comes to the right to access your personal data, the reason why this is an absolute right is that it's the basis under which all other rights under the realm of data protection can be exercised. So the right to access your personal data is absolute and cannot be denied. And if anybody denies you the right to access your personal data, then you come to our office and raise that complaint to us. And that will be a reason for us to actually take enforcement action against such a data controller or such a data processor. The requirement period for enforcing this particular right, rather for ensuring that the right has been met, is 7 days. So data controllers and data processors have 7 days to comply with your request to access your personal data. And it is also important to note that you should not be charged to access your personal data. This right should be free of charge. There should not be any cost infliction. So assuming if I wanted my bank statement from my bank, I would reach out to my bank and request for that for my account statement, and the same should be given to me free of charge. And then we have the right to correction of false or misleading data. This means that if any data controller or any data processor has information on you that is inaccurate, untrue, incomplete, or even outdated, you have the right to actually apply for the correction of that information. But it is also important to note from where you sit as a data subject, you have to support your application with the relevant document or the relevant evidence that is required. And also, this right should be free of charge. You should not be charged to exercise your right to correction of false or misleading data. Then we have the right to deletion and the right to erasure. Catherine spoke on this, so I'll just move on to the next right, which is the right to data portability. This is a unique and a new right that's being applied based on the automation processes that we have in place and the developments we have seen throughout the ICT industry and in the tech space as well. So in short, what this means is, assuming you're on one social media platform and you want to move to another social media platform without losing the content that you have created on platform A. So this right allows you to actually move or to port your data because you are the one who's generated that content. So assuming you're moving from TikTok to Instagram and these two social media platforms are compatible, then you have the right to exercise your right to data portability. We have automated decision making. This right allows you as a data subject not to be subjected purely to a decision that is made by automated means. So assuming you're applying for a loan and there's no aspect of human intervention in making that application, and the outcome of that decision is disfavorable to you as an individual, then you have the right to actually request recourse or the intervention of a human being and to see whether the human being would have arrived at a similar decision that was taken up. By example, for example, if the entity was utilizing artificial intelligence to actually make that decision. The right to processing has been spoken about, so I'll speak on exercise of rights, your rights as a data subject by other individuals. So minors do not have the capability to exercise their rights to data protection. So we expect that either parents or guardians will be exercising these rights on their behalf, noting that minors are considered to be vulnerable persons within our society or within our context. And then the second aspect is persons with disability. So persons with disability also lack capacity to exercise their data protection rights under our framework. So the expectation is that whoever has been appointed either as a guardian or as an administrator will have the responsibility of exercising these rights on behalf of such persons. And also as an individual, if you're incapable of exercising your rights, then you have the power to appoint someone to exercise those rights on your behalf. A good point to start would be through a power of attorney, whereby you grant your rights or you give the power to someone to actually act on your behalf. So the requirement from our office is, if you're coming to exercise these rights on behalf of others, you need to provide evidence that you actually have the responsibility of, or you have been entitled by the law to act on behalf of the various categories of individuals that we have identified. The lawful basis of processing, they've been spoken about. So consent is not the only lawful basis of processing. So consent is not the only reason why someone would ask for your personal data. If, for example, you have a contractual agreement between you and, let's say, your service provider, your internet service provider, then in such a situation, there's a legitimate basis for them to be processing your personal data. We also have the other grounds for lawful processing of personal data. We have a legal compliance with a legal obligation, as both as we've been told, for example, with Safaricom, when they're asking us to register or to re-register our SIM cards, they are complying with a legal obligation that has been set out under the Kenya Information and Communication Act, as well as the SIM card registration regulations that were issued by the Communications Authority of Kenya. So they have a lawful basis for them to actually do that. And then we have instances where someone is protecting the vital interests of a data subject. We have public interest, we have public authority, we have legitimate interest, and then we also have, for purposes of historical and scientific research, there's a legitimate reason for people to actually collect your data. And then I'll speak slightly on what is called a data protection impact assessment. So this is an impact assessment that data controllers and data processors are expected to undertake in instances whereby they're about to take up what we call high risk processing activities to the data subject. So the activities that have been considered high risk have been highlighted in the general regulations 2021, and these ones include whereby someone is going to use automated decision making, which has a legal or similar effect in that it will deny the data subject an opportunity for them to actually exercise their rights. Then there's a requirement for them to carry out a data protection impact assessment, where they're using personal data on a large scale, where they're also processing biometric or genetic data. So assuming someone is collecting your fingerprints or even collecting your genetic data. And something to note is that with the Huduma registration process that was going on earlier on, I think that had been started in 2019 to 2020. One of the requirements was when the whole process was challenged in court was that they needed to carry out the data protection impact assessment based on the fact that they were actually processing biometric data, being our thumbprints and our fingerprints as well. So we have various instances whereby data controllers and data processors will be required to carry out a data protection impact assessment, submit the report to us. We will review the report and then give them feedback on areas whereby they need to adopt or increase on the security safeguards that they have put in place to ensure that people's privacy and people's rights to data protection are observed. And then we have obligations of data controllers, and this will speak to what can businesses or companies do to make sure that they are compliant. First point of call is registration. You need to register if you're operating as a data controller and a data processor. So registration will be starting this year in July, from 14th July. That is when we'll be registering data controllers and data processors. And the reason why the registration process is starting in July is that on publication of the registration regulations, the same take effect or come into force 6 months from the date of publication. So the regulations were published in 14th January this year. So 6 months takes us to July 14th this year. So we'll commence the registration process in July. So once you register, you'll be issued with a certificate of registration, which will be valid for 2 years. And then upon the expiry of the 2-year duration, there's an expectation that you would renew your application or renew your certificate if you're still processing personal data. And then there's the requirement to appoint a data protection officer. It's optional. The Act does not require mandatory appointment of a data protection officer. But if you're processing sensitive data, or if you're processing operations of what you would classify as large processing operations, we do recommend that you appoint a data protection officer, because the role of the data protection officer is to assess your level of compliance with the Data Protection Act, noting that processing activities are activities that happen on a day-to-day basis. So they would help you in terms of monitoring compliance and speak to points of improvement to ensure that you're compliant with the existing framework. The other obligation we have, this will speak to the question of how do I implement data protection? So we recommend that organizations adopt data protection by design or by default. And in short, what this means is you design the data protection principles into your system. And in an instance where you're not able to design, then the default is that they're already in place. So assuming you're coming up with an application, a new application, maybe for a taxi hailing application, how have you implemented the data protection principles into your operations? How long when I talk about the principles, I'm speaking to things like storage limitation. How long do you keep the record of a right that has been ordered through your application? That's what we mean. You think through all aspects of data protection and aspects of privacy in any application that you have in place. If it's in the physical sense whereby your processing operations have not been automated, then if you maybe collect personal data and you have a file, where is that file stored? Assuming you store it in a filing cabinet, do you lock the filing cabinet? Assuming if you lock the filing cabinet, where do you keep the key? So those are the small things that we're talking about. These are practical steps that organizations can adopt. So think through your processing operations and think how best can you make sure that your processing operations reflect the data protection principles. The other step is you need to have a data protection policy in place, and this policy will speak to your data subjects in terms of you will let them know, number one, what information you hold about them or what information you collect about them. How can they access this information? How can they exercise their rights, the rights that they have under the data protection framework? Do you have an internal complaints handling mechanism in an instance whereby I feel I have been aggrieved by one of the processing operations? Am I able to reach out to you as a data controller or a data processor to make sure that my grievance has been handled? And also in terms of lawful purpose of processing, what lawful basis of processing are you relying on? How long do you keep this data? So these are the aspects that we expect all the data protection policies that the data controllers and data processors have will speak to. And then lastly, carrying out a data protection impact assessment test where there is need. And then if you are unsure, we recommend that you consult with the data protection commissioner on how to go about it. So any inquiry to our office on whether you need to carry out a data protection impact assessment as a data controller or a data processor will respond to you and guide you on how you should go about it. The other aspects we have, there's an expectation for there to be a written agreement between data controllers and data processors, and there are specific aspects that data controllers and data processors should ensure that have been captured in those contractual agreements between these two parties. In instances of breach, there is an expectation that where there has been a breach of personal data, and these are the responsibilities of the data controllers and the data processors. So once you become aware of any breach of personal data, you have 72 hours to report the same to us. And in instances where you do not report the same within 72 hours, then you need to give a justification as to the delay in reporting the same. And then also you need to communicate the breach to the data subject where information about them has been stolen or has been breached, or where they're at a high risk based on the breach that you have experienced. And then the aspects of data localization. So the requirement for data localization speaks to processing activities that need to be carried out within Kenya. So in short, what we are saying, you either process the personal data you have within the boundaries of Kenya, within the jurisdiction of Kenya, or if not, then you need to ensure that you have at least one serving copy of personal data located in Kenya. And if I could take you back, I don't know whether you remember during the election period, we had the situation of the Fungua server. And in short, that is partly what motivated this aspect of data localization. And based on the policy decision that had been taken and the legal position that is currently in our Data Protection Act, I think we've seen an impact of this in that we've seen the major players operating in the space of cloud computing coming into Kenya and actually setting up businesses in Kenya to ensure that they help entities actually meet this requirement of data localization. So entities that are required to localize their processing operations, we have any entity that is administering a civil registration or legal identity management system. So when we talk about this, with think of the registrar of persons, registrar of debts, Huduma Secretariat. All these entities are supposed to ensure that they localize their data. We have any entity that is conducting elections for representation of the people. Think IEBC. Any system for administering public finances by any state organ. So this is financial information by any public entity. Then we are required also to localize our operations in relation to that. Anybody who's running any system that has been designated as a protected computer system. So this touches on aspects such as M-Pesa. We have mobile network operators who've been required to act, who've been designated as protected computer systems. And the result of that is that they are now required under our framework to localize their processing operations. And then we have schools and people who are in the health industry offering both primary and secondary healthcare to the data subjects. We have aspects of cross-border transfer of personal data. So we require that any data controller or any data processor who's transferring personal data outside Kenya to, number one, establish appropriate security safeguards prior to the transfer of personal data. So assuming I'm a data controller and I process personal data and I'm transferring that personal data to Uganda. So before carrying out the transfer, I am required to ensure that I have put in place, or I need to ensure that there are appropriate safeguards to where this data is moving. That would be now Uganda, to make sure that the rights of data protection and privacy of the data subjects is protected. So the safeguards contemplated under the regulations are any country that has ratified the Malabo Convention. This is the African Union Convention on Cybersecurity and Data Protection, is considered to be an appropriate safeguard. I think so far we have about 14 countries in Africa that have ratified that convention. In the absence of a ratification, whereby we another appropriate safeguard would be a reciprocal data protection agreement with Kenya, with now us as a country. And then lastly, we have contractual binding corporate rules among the concerned entities. So assuming a good example would be Safaricom PLC is transferring personal data to about Kenyan citizens to their Ethiopia branch, then the existence of a corporate binding agreement between these two particular entities, just speaking to matters of data protection and what security safeguards and the principles that will actually govern the processing of that personal data, then we do consider that as an appropriate safeguard. And then the registration process, it's pretty straightforward. So the expectation is that data controllers and data processors will apply on our website to register as either a data controller or a data processor, or as both. And then upon making the application, you also be required to pay the requisite fees. And then once we receive both your application and your fees, we will verify the details that you have provided to us as a data controller and a data processor. Once we verify your application, then you will be issued with the certificate for registration, and then which will be valid for 2 years. And then after the 2-year period, then you come back and renew your certificate, your registration certificate. The fees are set out in the schedule. I'll share this presentation. But the minimum fees payable for registration, so the initial registration, is 4,000, and the maximum fees payable is 40,000. And then during the renewal process, the minimum fees payable is 2,000, and the maximum fees payable is 25,000. And then we have aspects of mandatory registration. Let me just speak to this. So everybody is required to register under the Data Protection Act, but an exemption has been given to entities that are classified as micro, small, and medium enterprises. And for you to be able to know whether you fall under that category is number one, you carry out an assessment of your turnover. So if your turnover is anything below 5 million Kenya shillings, then you're considered to be a micro, small, and medium enterprise. or in the absence of a turnover, you employ less than 10 people in your organization. So there's no requirement for you to register if you fall under that category. But assuming if you fall under that category and your processing activities touch on the categories I have on the slide right now. So if you're canvassing for political support among the electorate, if your business is in gambling, if your business is in crime prevention and prosecution, if you're operating an educational institution, if you're in the business of health administration and provision of patient care, if you're in the hospitality industry, if you're in the property management industry, if you're providing financial services, if you're in the telecommunication network and service provider industry, if you're in direct marketing, if you're in the transport service farm industry, or if you're in the business of dealing with genetic data, then you have to register with our office. There's a mandatory registration for anybody who's operating in any of those industries that we have identified. And then consequences of non-compliance, what will happen? In the first instance of non-compliance, the office will issue you with what we call an enforcement notice. So an enforcement notice will outline aspects that the data processor or the data controller is non-compliant with, and also the actions we require you to take to ensure that you're compliant. This notice will be valid for 30 days. So within those 30 days, if you fail to take any action to actually comply, then we'll issue you with what we call a penalty notice. And a penalty notice will outline the points of non-compliance, as well as the actions that you are required to take. And failure to comply with the penalty notice will attract a daily fine of Kenya shillings 10,000 for each penalty or each point of non-compliance that has been identified until you actually rectify that aspect of non-compliance. So, and then we have exemptions. There are specific operations that don't fall within our mandate as the Office of the Data Protection Commissioner. This touches on personal or household processing. So if, for example, you're asking your spouse for their shoe size so that you can buy them a shoe, that doesn't fall within our mandate. That's in the private realm, and we don't regulate that aspect of processing personal data. Matters of national security or public interest have also been exempted, as well as the court. The court has authority to give a court order to exempt certain aspects of processing from the ambit of our law. So that's it for me. Thank you for the time.
Thank you very much, Rehab, for that presentation, indicating what you do as a commission on the issue of data protection. I think we've received a rich mix of presentation up to now. And personally, I think I'm already very much well informed about the subject of discussion today, more than I was before I started. So we have a poll that is running. I don't know if you've seen it. So please just take a few seconds to respond to the polls, to the questions that are listed there, so that we can be able to have an idea what your views are. We also have a hashtag data protection for those of you who want to tweet. Our hashtag is data protection. So please, if you are tweeting, put that as the hashtag, and you can also tag us. Our handle is KARA_CARES-KE. KARA_CARES-KE. So I want us to just take a few minutes, the next few minutes, just to also hear from you. Like I said, we have plenary, and I've gathered that most of the questions that were asked previously and also in the chat box, a number of them have been covered through the presentations. So we really don't need to go back to them. But if you have a question to any of the presenters, please carry your hand up. I'm sure you know how to do that. You can lift your hand, and then I'll be able to give you an opportunity to ask your question. And please, when you do, specify which presenter you want to respond to it, and also be as precise as you can. I can see already there's a hand up. Helen Washuka. Helen Washuka has a question. So please, our team, just enable to ask the question and mute her so that you can ask. Helen, can you proceed with your question, please? Helen Washuka. Okay, I think she's not unmuted. Any other question from the participants? Please lift your hand up, we'll pick it. Victor Juma, can we unmute Victor Juma to ask his question?
Thank you so much. Good evening.
Good evening.
Yeah, thank you so much. First of all, I want to appreciate our moderators and the presenters who have done a good job, and I've been following the training closely. My name is Victor Juma. I'm a journalist. I work with a community radio in Kajiado called Bus Radio Sauti Kajiado. And I just want to ask a brief question on matter of data protection. I understand that there's law, which I've seen our previous immediate presenter Rahab talking about it. Most cases, when we are trying to access data from the county government, especially when we're following up on budget process, for instance, financial year 2019, 2020, 2020, 2021, 2021, 2022, especially from the CEC finance, it becomes a quagmire, or it becomes a challenge to access that data because when you go there to request for the data, it becomes a challenge. They tell you, write a letter, go to this office, go to that office. And even if you have written a letter and followed the laid down processes, it still becomes a challenge for a journalist like me to access that data, whereby that data should be there or should be put on their website for public interest. So here we are as a journalist. We want to do or follow up a story on how certain money was spent. There was a bridge that was built and it said that it was 30 million or 10 million. But when it comes to the data, you find out that they don't reflect that on the final data. And when you try to access such kind of data, the county government officers who are in charge, especially the CEC office, which is in charge of such kind of information, they become harsh on us. So how can we, as journalists, especially me as a journalist, access that data to ensure that I get that data for the public interest, use that data to the public interest so that the people can understand how finances or how budget is being done in our county? Thank you.
Thank you very much, Victor, for that question. I think one of the panelists will respond, but I know there's a law on access to information. Perhaps we need to have a session specifically on that, because I know the law provides on what the consequences are of being denied certain information. But we'll get to hear. Perhaps Rahab could be able to take that when we get back to the panelists. So Helen, are you able to ask your question now, or we go to the next one? Helen Washuka? Okay, I think there's still a problem. Can we have Alfred Lutete ask his question, please? Alfred Lutete Lusambia. Please unmute Alfred to ask his question. Alfred? Okay, Helen, proceed. I can see you're unmuted. Okay, please mute Helen. I think she's in a very noisy place. Please mute her. Can we have Shelton Amwai to ask his question? Shelton, please proceed. Yes, yes.
Thank you for the session. Mine is not really a question, it's just a concern. Would you mind
Yes.
if you send the PDFs to our email so that we can be going through them in our free time?
Okay, the presentation will be shared on email with all those registered, so that will be done immediately after this session. So we have Alfred still not able to ask. I can see that is still up, but I think you are not able to unmute your mic, and Helen as well.
My question was about how would we get the syllabus about this training, and also, if possible, how can we get a certificate for participation?
Okay, Alfred, I think this is just a webinar for educate the public, so we may not have a certificate, but like we said, we'll share the presentation and we can talk about that maybe later on after this session. So I want to take it. Albert Mwangi, you want to ask your question?
Yeah, I got an answer about a PDF for the note.
Okay, Alfred, I think I'll talk about that later on. Let's have Alfred Mwangi to ask his question. Okay, I think there's a problem with that. So we want to get back to the panelists as we come as we wind up this session. And as you respond, maybe starting with Catherine, there was a question that was asked about, given the current progress you are making in terms of data protection and implementation of the Act, where do we see Kenya in terms of data protection, perhaps in the next 5 years? Basically, the question is, are we on the right track in terms of implementation and in terms of embracing best practices? And maybe 5 years from now, could we be able to say that we've made significant progress in that regard? And then the second question, which Rahab could tackle as we respond, is how will the relevant authorities, and in this case, I believe it's the Commission, monitor the implementation of Data Protection Act by individual organizations? So in short, is that are there already frameworks in place that will ensure that you are able to monitor compliance and take action where there's need to take action? And then maybe Rahab can also be able to respond to this one. There's somebody asking that phishing with a P is on the increase and we need civic education. So the question is, how do we ensure that we are able to reach the ordinary people, they're calling them Mama Mboga, with this information about data protection, so that every person across the country understand what the law talks about and what records exist for them should there be a breach. And then the last one, and then which could be handled by Safaricom, one of panelists from Safaricom. Does the Act complement the Computer Misuse and Cybercrimes Act? That was by Joy Mardeka. So the relationship between this Act and Computer Misuse and Cybercrimes Act, so that maybe that can be handled by Safaricom. So ladies and gentlemen, I want us to start getting to the end of this. And I'll do that by getting back to our panelists in the order in which they presented, and ask Catherine to respond to that one question that I'd raised. And of course, if there's another question you feel you need to tackle that was asked, please feel free to do that. And as you do that, you also can be able to make what you could call your final remarks. So Catherine, please get back to the floor and respond to that.
Yes, thank you for that question, Henry, and for the person who's asked that question. So basically, they've asked me to address the state of privacy in Kenya, where we've come from and where we see ourselves in 5 years. I have to say, if you think about privacy, it's sort of like a global movement, and there's so much pressure globally for organizations, institutions, and even governments to take the matter of privacy seriously. So apart from the global pressure, which say led to the EU GDPR, and even in our country, the Data Protection Act, and other African countries, we are increasingly also seeing other African countries adopting data protection legislation, because from the angle of trade, so much pressure is being put on, say, the trade angle as well, where governments are being told, we can only trade with you if you have data protection legislation. So I foresee, because where we were 5 years ago is not where we are now. I foresee a leap. There's also the element of awareness of privacy. More and more data subjects are aware of the rights that they have relating to privacy of their personal information. And I think one of the efforts that we've seen the Office of the Data Protection Commissioner, we've seen them for the last year or so inject a lot of energies and efforts towards awareness and creating an awareness on the ground. And now with organizations such as KARA jumping on that bandwagon, and even people like organizations such as Safaricom saying that as much as we are on this other side of being regulated, let's also onboard the aspect of creating awareness. So then I expect that we'll make leaps. And also we've seen organizations adopt the aspect of taking privacy seriously as from a competitive advantage angle, where like now an organization such as Safaricom can say, you know, apart from what the law requires us to adhere to, we have gone over and above, and there are these other privacy aspects that we have implemented to just make sure that your privacy is at a higher threshold. So then we'll see more and more organizations coming out and taking a competitive advantage and telling people, you know, it even becomes a marketing tool where they say, you know, us guys are compliant, you know, we're compliant with the act, we know we're compliant with EU GDPR. And also commercially, it helps them say do trade, say with like companies that are in Europe. It's a marketable thing when someone says we are EU GDPR compliant. So then it's a win-win situation. And I think that's where we'll see ourselves in the next year or so. Hopefully I've answered the question.
Thank you very much, Catherine, for that. I'm sure you responded to the question. Can we have Fiona perhaps taking up any of the question and responding to the one that we had direct to Safaricom? Fiona, please.
Thank you, Henry. So I will tackle whether data protection act complements the computer misuse. I think Agnes had already talked about it. So yes, it does complement the Computer Misuse and Cybercrimes Act. You will see a lot of reference to the Cybercrimes Act. For example, there's a place when the data regulations actually talk about when you're processing data outside the country, one of the things you need to consider is whether you have a protected system. And when they go further to explain what protected system is, they make reference to critical systems under the Computer Misuse and Cybercrimes Act. So you can find a lot of reference, cross-referencing within the two statutes. Thank you, Henry.
Okay, thank you very much. I've noted that Agnes had touched on that briefly, so we don't need, and we've also talked about it, so we don't need to go back to it again. So in that case, unless Agnes, you have something to say, maybe we could go to Rahab. Agnes, did you have something to respond to?
Yes, I'll respond to a question that I've picked from the Q&A box. And this has been asked by an anonymous attendee where they're asking what recourse there is for them for the unsolicited voting demands. So some of the content partners or premium rate service providers we have are actually used by political parties to disseminate info regarding their campaigns, where they're going to be, or soliciting for votes for various aspirants. And a condition is there that every message has to come with an opt-out, which is the *456 hash that I had earlier said. I think I'll also put it in the chat so that whoever receives this kind of messaging and does not want to receive further messages can just dial the code that is *456 hash and stop any more political messages coming from that particular party. Unfortunately or sadly, as the case has been, is our data is all over the place, and the Data Protection Act came in after. A lot of our phone numbers have been left in books in buildings, and some unscrupulous people would go and take photos of those numbers and names. And so, somebody somewhere, politician somewhere, has a record of your name and your number. And I would just like to reiterate and assure our customers that that does not come from mobile network operators. We are not allowed by law to share your data without your consent and to provide that kind of data to such persons who then use it for spamming. Remember, we're also subject to anti-spamming rules. We ourselves cannot do it to you. So we would not allow somebody else to do it to you. But power to the people, *456 hash is your recourse. Thank you.
Thank you very much, Agnes, for that. I've seen a few more questions to Rahab. Maybe as you come in, you can be able to respond to them. And one of them is actually on the chat box. Has the data control and processor registration, process kicked off? And then I think there was another one about what recourse exists for unsolicited voting demands. And there was another that is also similar by Usalama Forum, asking what should be the impact of data protection against management of political parties in Kenya. They're saying that the scrupulous individuals pick people's contact to sanitize political parties in this country. Telcos in this country also as guilty as charged. So I think those are directly to Rahab. So as you come in, please can also be able to respond to that. So Rahab, please proceed.
Thank you, Henry. On the registration process, no, it hasn't kicked off. It's going to start on the 14th of July this year. So that's when that's the start date to the registration of data controllers and data processors. In terms of the other question, in terms of what's the impact of the Data Protection Act against management of political parties, I don't know how many people have had the benefit of logging onto the website of the Registrar of Political Parties, or even on your eCitizen account to actually search whether, number one, you're registered to any political party. And the second aspect, if you're registered to a political party that you're not affiliated to, whether you can actually deregister yourself. So there's a framework that was developed late last year. I think sometime in September, there were issues about people being registered to political parties that they were not affiliated to or affiliated with. So what we did in conjunction with the Office of the Registrar of Political Parties is we put a framework in place to allow people to number one, search whether you're registered with any political party, and number two, deregister yourself if you're not affiliated with that political party. So in essence, those are some of the steps that we're actually taking to ensure compliance with the Data Protection Act. And then the second question is, so in instances whereby you find that you are registered to a political party, that you are not affiliated to, that means that they are processing your information without your consent or even without even a lawful basis, then you could come to our offices and complain. If you go to our website, we have a complaints tab whereby you fill and you give us the details that are required. You see the information that we ask for. You required, number one, to identify yourself, and number two, to identify the entity you're complaining against, and then the aspects which particular aspect of your right to data protection has been infringed. So in this particular instance, you'd be complaining and saying that this political party is processing your personal information and they have no legal basis to do so. So what we would do is would take up a joint enforcement action between ourselves and the Office of the Registrar of Political Party to ensure that the political party is actually complying with the data protection framework. In terms of the third question, in terms of monitoring compliance, how do we monitor and ensure compliance, and also what actions are we taking? So one aspect of monitoring compliance is the requirement for data controllers and data processors to register. We need to be able to know and appreciate who's processing personal data within our ecosystem. And something to note, the registration process will actually be an assessment of your levels of compliance. So point to note, you can be denied a certificate of registration where by your levels of compliance are not in line with what is provided for under the Data Protection Act. So that's one of the ways in which we'll be monitoring compliance as an office to the Data Protection Framework. And then the question on phishing, whereby phishing is on the increase. So there is a need for public awareness for sure, because what we are pushing for is for entities to adopt ethical data practices, whereby you are able to disclose to this person why, number one, do you need their personal information? What are you going to do with your personal information? How long are you going to keep their personal information? Will this information be shared with any third parties? Just letting people be in the know of what the personal information is going to be used for. So phishing is on the rise. We recognize that, and that's how most people end up being targeted. So we recommend if you receive, for example, an email and you're not even familiar with who the sender is, we recommend not opening it, and also being cognizant. And are you able to see? Because some of them may be disguised as an entity that you recognize, but you need to pay attention and to be keen on the sender of that particular email. We recognize it will take a lot of awareness creation for people to appreciate the value data protection actually brings to both business entities and to the data subjects at the end of the day. And it's one of the key pillars of our strategic plan. I hope I have answered all the questions.
Sure, Raya, you've done well. I think you've responded to the questions very well. And of course, this now brings us to almost the close of this session. And before we close, I know it's always good just to ask the panelists if they have any closing remarks, which they should. So I'm going to ask as we close, and of course, I'm going to make our closing remarks after that. Catherine, you made a very good presentation. So do you have any closing remarks as we come to an end of this?
Thank you, Henry. Not really, but maybe just to thank the audience and to thank my fellow panelists as well as KARA and Safaricom for organizing this. It's been an absolute pleasure just to have thought-provoking conversations, and it's been quite insightful, even for us as practitioners. So thank you very much.
Okay, asante sana. So Fiona, as you make closing remarks, there was one question, either you or Agnes can respond, which perhaps we need to listen to. Is Safaricom in charge of the CCTVs on the streets, and where is this data collected taken? I don't know if you can be able to give a response to that as you make your closing remarks.
Agnes will respond to that. What I want to say as closing remarks is thank you for this platform, Henry. I hope that we'll continue collaborating and also bring more people, more stakeholders, Airtel, Telcom, banks, so that we have these discussions, because these are very pragmatic questions and actually concerns that people have on the ground. So thank you for this platform.
Okay. Agnes?
Thank you very much, Henry. I would like to first thank our audience because this would not have been possible without them. And it has also been very good to be put on the spot by the audience. It makes us reflect on the things that we are doing as data protection and privacy champions and practitioners. And I would like to commend them for their patience to listen through. The questions that they have asked shows that indeed they do understand this issue of data privacy and data protection is critical, not only for businesses, but even for the data subjects and other kinds of businesses, because a lot of people tend to think it's only big businesses that are tasked with data privacy or data protection. I would also like to thank KARA very much for availing the platform and for partnering with us and for constantly collecting info on what the membership requires. It keeps holding us on to account as a responsible corporate citizen, that indeed it is you and your members that we serve out there, and we have to mind our actions, to align them to the laws, and to also employ very collaborative approaches in whatever it is we do. Now, to answer the question on whether Safaricom is in charge of managing the street CCTVs, the answer is no. Once upon a time, Safaricom was awarded a tender to set up CCTVs, but that was for the police force. And once we completed that, it was handed back. So no, that is not our responsibility. We do not manage them. We do not collect the data. The data commissioner is not only also a data commissioner for private entities, but also government agencies. And I am sure Rahab would be happy to respond on behalf of government and the government agencies on what they have done to ensure that they too are held accountable for the data that they collect. Thank you and have a good evening.
Thank you very much, Agnes, for that. And Rahab can make your remarks. And as you do that, just one burning question that has been picked, and maybe you can respond to it. And there's a question that there's a news on KARA intention to use intelligence solution to be able to read people's WhatsApp messages. So the question is this legal and in line with the Data Protection Act? Perhaps you can respond to that also as you make your closing remarks.
Before I make my closing remarks, there's a question that had been asked by a gentleman called Victor. I think the concern in relation to accessing data from county governments, you could take up that conversation with Office of the Ombudsman, Commission of Administrative Justice. They're the ones who are responsible with implementing the Access to Information Act. So if you're having any challenges with actually accessing public records, then you could write to them and they'd be able to follow up with whichever county government it is that you're having challenges with in terms of accessing public records. The question on KARA, I'm not certain how accurate those reports are. I would need to confirm first before we speak on it. I don't think KARA has published anything on the same, so I will hold on responding to that. And back to what Agnes had said, yes, we are mandated with regulating not only private entities, but also government. We recognize that government is one of the largest data controllers, if not the largest we have within our ecosystem. So our mandate doesn't only lean on regulating private entities, we also do regulate government operations in relation to processing of personal information. My closing remarks, I'd like to thank my fellow panelists, Fiona, it's nice reconnecting with you from today morning. Catherine and Agnes, nice meeting you as well. I'd like to thank KARA for organizing this session. I think it goes a long way in creating awareness and helping people understand what rights they have, and also allowing them to say no where they feel they are uncomfortable with whatever actions are being taken against their personal data. So hopefully, I hope we all go out there and become disciples of data protection, now that we recognize what value it does add to our lives and to our ecosystem as well. Thank you, Henry. Thank you for having us. We look forward to more engagements like this where we're able to raise awareness and help people appreciate their rights to data protection. Thank you.
Thank you very much, Rahab. Maybe just before we close, just quickly on the poll questions that we had posted, we have the results. So the first question was, are you aware of the Kenya Data Protection Law and your rights to privacy? 80% of the participants said yes, they're aware of the law and their rights, and 20% said they are not aware, no. And then the second question was, have you experienced any case of your personal information or data being compromised or in a data breach? 49% yes, 49% no, almost a tie, actually it's a tie. And then the third question is, do you believe data protection is a shared responsibility between the customer and the organization collecting personal information on its users? 88% said yes, 13%, I think this should be 12%, said no. And then the last one that was asked is, would you like to see increased government regulations around data privacy? 94% yes, 6% no. So clearly people feel that we still need to do more in terms of data privacy and protection. And I think the journey is on course through the Data Protection Commission. And certainly we should be able to make significant progress in the coming days. So I want to thank all of you for creating time to be part of this discussion. Our panelists, Fiona, Agnes, Catherine, Rahab, thank you for the excellent job. This was a power panel of ladies that have made very, very insightful presentation. So asanteni sana for that presentation that has made us the better in terms of information. To our participants, we certainly could not have had this without you. So we appreciate you. Thank you for joining in. Thank you for being staying on until this particular point. And we ask you to continue participating in more of this forum, because at the end of the day, information is power. So if you have information, then you can be able to make right decision and take right actions as a responsible citizen. So thank you very much, and we hope that you found it useful. We hope that you are now more informed as far as the issue of data protection is concerned. Safaricom, our partners, we can't thank you more. You've been with us through this journey for very many years, and we look forward to continue working with you. So thank you for partnering with us in putting this discussion together, and we are going to discuss and agree on what our next discussion will look like. So thank you for the support and for always responding when we reach out for partnership. So ladies and gentlemen, allow me to bring this to a close and wish you a very nice evening, and also urge you to look out for our next engagement, which we'll be communicating soon. So asanteni sana, and God bless. You are free to log out. Thank you.